Good afternoon, good morning, and welcome to this side event of Singapore Convention Week, getting the most out of the Singapore Convention in investor-state disputes. My name is Jan Calamita. I'm the head of investment law and policy at the Center for International Law at the National University of Singapore. And I'm very delighted to have so many joining us today and to have such great experts to speak with us today on these issues. What we're going to be trying to do is to provide a practical update and an examination of the role of the potential of the Singapore Convention in resolving investor-state disputes, particularly investor-state disputes arising under treaties. We'll do so by examining questions involving the applicability of the treaty or the convention, its current status in terms of ratifications and signatures, looking at the state of play of reform more broadly across UNCITRAL and ICSID, and then the practical issues that are raised for investors, for states, and for mediators as this space develops. I'll be starting us off with an overview of the developments, and then we can move on to the real experts on the panel, those who are in the trenches, so to speak, working with government, working with investors, working as mediators. In order of appearance, we have with us today Bart Leggum, my old colleague at the U.S. Department of State, and now founding partner at Onlay Leggum in Paris. James Claxton, professor at Waseda University in Japan and well-known commentator on mediation. And Daphne Hung, the Director General of the International Affairs Division at the Singapore Attorney General's Chamber. So without more, just to set it up a little bit, I'll give a brief presentation, then our speakers will give brief presentations, but we hope to make this an interactive discussion among participants and with you as well in our audience. So please do use the chat function to put in questions that you'd like to have raised, and we'll do our best to get to as many of them as possible. Let me start by sharing my screen and providing this overview of getting the most out of the Singapore Convention in investor-state disputes. And I'm going to do this in three parts. First, what's been happening in the mediation space outside of the Singapore Convention, particularly with respect to the UNCITRAL Working Group 3 investor-state reform process, as well as at ICSID, with ICSID's new rules on mediation, and then concluding with an overview of where things stand currently with the Singapore Convention. So let's just begin by looking at ICSID's rules, which were adopted in March 2022 and have been effective since the 1st of July 2022. An entirely new space for ICSID, moving into arbitration, creating a system or set of rules whereby mediations can be administered by the ICSID Secretariat, so long as the disputes relate to an investment and involve a state and contain the parties' consent in writing. But what's interesting about this is, compared to other ICSID mechanisms, it's not necessary that the investor and that the state be of different nationalities, and indeed there's no requirement for either party to be linked to an ICSID convention member state, thus making the initiative for mediation rather different than the convention-based system of conciliation that ICSID has traditionally had. One of the interesting issues that arises in connection with the ICSID rules on mediation is with respect to how the agreement to mediate can come into existence and be perfected. And the ICSID rules make clear that it could be in a contract, it could be in an ad hoc agreement providing for ICSID mediation, perhaps after a dispute has arisen. It can also be based on provisions in an investment treaty or in a state investment law that grant access to mediation by the state and the acceptance of the offer of mediation by the investor, much in the same way that the agreement to arbitrate is created under investment treaties and foreign investment laws. But they are also clear that one doesn't even need to have consent to mediation before filing a request for mediation, because the request itself can serve as an offer to the other side that mediation would be amenable. The rules are drafted to ensure a significant amount of discretion and autonomy to the parties themselves, including with respect to the number of mediators that might be appointed. And ultimately, the rules contain processes to ensure that mediation does at some point conclude, namely either through the conclusion of a written settlement agreement pursuant to the mediation, or an agreement to terminate the mediation itself, or ultimately through the mediator's own determination that there's no likelihood for mediation to succeed. So these were, as I say, concluded in 2022, came into force in July 2022. To my understanding, at this point, ICSID has received one request for mediation under the mediation rules. But there is, I think, an expectation within ICSID and elsewhere that there will be an increase of these rules going forward, reflecting what I think we'll talk about, which is the increased interest in alternative dispute resolution mechanisms like mediation by both investors and states. Mediation's also, of course, been on the agenda at UNCITRAL, and much of this week already has involved UNCITRAL and talking about mediation. But the involvement of UNCITRAL that we're referring to here is the involvement in Working Group 3 on the reform of investor-state dispute settlement. And just this past July, the full commission adopted UNCITRAL's model provisions on mediation and UNCITRAL's guidelines on mediation for international investment disputes. Obviously, it's early days with both of these, although they have been under discussion for several years at least. But to look at the provisions on mediation, the idea is not to attempt to create one-size-fits-all treaty language, but to provide states with options. And the principal option or division of the options is whether or not the treaty language either encourages the parties to use mediation or requires them to do so as a precondition to access to arbitration, let's say. But the provisions go on to address many of the issues that are they're important to establishing an effective mediation process, such as specifying the information that's required to commence the mediation, the issue of staying in arbitration upon commencement of mediation, transparency, confidentiality, ensuring that what happens in the mediation stays in the mediation and is without prejudice to issues and points and arguments that may later be raised in a contentious proceeding, and ultimately requiring that the parties ensure that a mediated settlement in its structure at least meets the requirements of the Singapore Convention. And we'll finish up by looking at those. Just to carry on with the UNCITRAL work having been completed this summer, there are the UNCITRAL guidelines on mediation. And these very much are guidelines. They are not prescriptive. They don't attempt to set out best practices, but they recognize that different cases will involve different issues, different parties, etc. But I think what they attempt to do is to flag for states and for investors some of the principal issues that need to be addressed and to be considered when undertaking an investment mediation. And again, I think these are going to be some of the things that we'll be talking about with the panel. Is this a suitable mediation for is this a suitable dispute for mediation in the first place? Ensuring that the consent to mediation satisfies necessary formalities, managing the timing and the duration of the mediation, assessing different rules under which a mediation can take place, how one might choose a mediator, what kind of role the mediator will play, his or her qualifications, the role of the parties, and how they can best approach a mediation in a constructive way, and so forth, particularly including ultimately confidentiality and disclosure, balancing the expectation and the desire for confidentiality among parties in conducting a mediation with the public interest in some kind of disclosure with respect to the outcome of disputes involving states. So it's pretty much a whirlwind of what's been happening at UNCITRAL and at ICSID. Let me finish up by setting the stage with the Singapore Convention itself. Briefly, and very briefly indeed, Singapore Convention has some essential requirements for its use, namely that settlement agreements must be the product of mediation, and those settlement agreements must be in writing. A dispute must be commercial and it must be international in nature. Ultimately, in the event of a mediated settlement agreement, to rely upon the settlement agreement requires the signed settlement agreement itself and evidence that the settlement agreement has resulted from mediation. And then finally, similar in some ways to the New York Convention, Article 5 provides a limited set of grounds for a competent authority to refuse to recognize or enforce a settlement award rendered under the convention. Where are we with the convention, and particularly where are we with respect to the convention and its role potentially in investor-state treaty-based disputes? Well, signatories have certainly increased over the past year. There are now 56 signatories, including a number of larger economies, Australia, China, India, Malaysia, Nigeria, Korea, the UK, the US. Perhaps notably absent from the signatories at this point are states of the European Union, who continue not to have signed. Signatures have not yet translated into as many ratifications. We still have 11 ratifications with generally smaller economies. Uruguay is the most recent, and according to UNCITRAL, its ratification will become effective as of the 28th of September. One issue of concern, I think, and perhaps we'll pick this up in the panel too, one issue of concern with respect to the utility of the Singapore Convention for investor-state disputes is that of the 11 ratifications we've seen so far, in four of them, the states have interposed a reservation by which they will not apply the Singapore Convention to any settlement agreement to which the state itself is a party, or which any government agencies or persons acting on behalf of the government are a party. Clearly, that is problematic for the settlement of investor-state disputes. With that, I hope I've sufficiently set the stage for our discussion, really more about some of the practical issues of dealing with mediation in the context of an investor-state dispute, how the Singapore Convention does at the moment or might in the future fit in. And let me start off then by stopping talking and by handing things over to Bart Legham to give us his views on evaluating investment cases for their suitability in mediation. That's the broad umbrella, but I'm sure, Bart, you will take us in other directions too, given your background as not only a practitioner but also former lawyer for the U.S. government. So, Bart, let me hand things over to you. Thank you.
Thank you very much. Let's see. Hopefully everyone can hear me. So as Janssen has just outlined, there's been a flurry of activity concerning investor-state mediation at ICSID and at UNCITRAL over the past years. However, despite this flurry of activity, investor-state mediation remains an animal that is often talked about, but rarely seen in the wild. It's still something that is relatively rare. And one of the reasons for that is that not all investor-state disputes are suitable for mediation, or at least not suitable for mediation at the part of the dispute where mediation is most productive. In other words, at the beginning of the dispute, before parties dig into their positions in a litigation or arbitration, and before they incur a large amount of costs. Why is that? I think that there's a number of explanations for it. Based on my experience, a case is best suited to resolution without a final decision of a court or an arbitral tribunal if it is not yet an investor-state dispute, but remains an investor-ministry dispute. What do I mean by that? I mean that it's a case where the investor has an existing relationship with the government, and typically through a specific ministry of the government. So if the investment is, let's say, in a road project, then the investor may have an existing relationship with the Ministry of Transportation. In that instance, the officials of the ministry know the investor knows the ministry. They have an incentive to work together in order to make their common project a success. And that's a dynamic where one can obtain results in resolving a dispute quickly, because there isn't this long period of becoming familiar with the investor, with the investment, and what's at issue that is the case in other contexts. And it also has the parameters and existing relationship that allow a negotiated resolution to be much more possible. If you contrast that situation to that which Jan Paulsen famously described in an article many years ago as arbitration without privity, in other words, an investor-state dispute where the government has no existing relationship with the investor, but instead the investor files a dispute under an investment treaty with the government, without having had any prior interactions with it. In that instance, several things happen. First of all, it's not a dispute necessarily with one specific ministry in the government. Instead, it's a claim against the state as a whole. And what that means is that there are typically a variety of different ministries involved in responding on behalf of the government. So let's say hypothetically that this is a dispute brought by a pharmaceutical company against the government concerning the regulation of a specific product in the pharmaceutical industry. Well, the Ministry of Health, of course, will have an important role as the author of the measure, but typically you will also have ministries like the Ministry of Justice, the Attorney General's office, in the United States, where I served for some time in the government. For investor state disputes, we had 7 different federal agencies that were part of a interagency group reviewing all decisions in investor state cases because of their broader interest in the government's policy in investment disputes. So it was the Department of State, Department of the Treasury, Department of Commerce, United States Trade Representative, the Department of the Interior, Environmental Protection Agency, and I'm sure I'm forgetting some. But at any rate, it was a large group. And whenever you have a large group of interested persons, it makes it much more difficult to come to a resolution. And it makes it also much more difficult to come to a resolution where the officials who are agreeing to a settlement of a dispute are putting their necks on the chopping block by exposing themselves to criticism for a decision that they didn't have to make. And that's a dynamic that one finds in a number of governments where it's hard to reach a settlement because there's a personal disincentive for the officials involved to expose themselves to criticism for their decision in arriving at the settlement, a criticism that they would not suffer to the same extent if the decision to resolve the case in a specific way was taken by a tribunal. So that's part of the dynamic that makes the single ministry paradigm one that is better suited for investor state mediation than the situation where it's a case where the investor has no privity with the state. The other thing that I would say is that it is much more possible, for an amicable resolution of an investor state dispute if the form of the settlement does not require the government to reach into the public treasury and pay money to the investor. Now, in commercial disputes, that's the most common way of settling a dispute, is through having a settlement agreement where one party pays the other party some money. That's a more difficult ask for a dispute with the government because there's more exposure. Taking money out of the public treasury means that there's less money available for other important public programs. And instead, what I have found is that settlements where it's not money, but rather modifications to a measure or some other non-monetary relief that is the ultimate outcome are much more common and much more easily obtained than monetary settlements. Although those, of course, give rise to a number of issues as to what is possible under national law for officials to do in resolving a dispute that is within their powers as government officials and in accordance with the law, but still achieves the common goal of resolving the dispute. I think I'll stop there and hand it over to you, Janssen.
Thanks so much, Bart. A lot of issues to come back to in our discussion, but let me turn things now to James Claxton. James, go ahead.
Jan, thank you very much. Thank you to the Center for International Law for this opportunity. I'm grateful. I was asked to say a little bit about what challenges face mediators in investor-state disputes. So what I thought that I might do is to identify, to my mind, what are 4 tensions that investor-state mediators must manage. So I'd like to identify the 4 tensions and then propose at least one possible way of bridging the gap. And then perhaps we could return to some of the issues, if you like, in the discussion at the end. So the first tension that I see is a tension between private and public interest. The parties to investor-state mediation are, of course, an investor and a state. These parties have different interests, and their structures reflect those interests. Investors have commercial objectives, and the form of the business, be it a corporation or a partnership or something else, is structured to maximize commercial objectives. States, of course, also have economic objectives, but they have many other priorities. For example, political stability and social justice. States are structured accordingly, as Bart has mentioned, with different agencies responsible for achieving different objectives. So I think these differences in structure and purpose come into tension in investment disputes. Imagine the construction of a highway by a foreign investor. And now imagine that a dispute arises over delays that the investor attributes to the state. The identity of the investor will be clear, but for the state, as Bart discussed, this international investment dispute might implicate the local government. It might implicate the Transportation Ministry, the Ministry of Justice, and the Ministry of Foreign Affairs, for example. In terms of objectives, the investor's objective is to be paid money damages for the state's contribution to the problem. The state's objective is more complex. The state will want, of course, to end the dispute quickly and avoid paying if it is not responsible, but the state will also have other considerations about settling the dispute. Will a payment to the investor encourage other investors to make claims? What will be the political consequences of a voluntary payment to a foreign investor to settle the dispute? Would that suggest corruption? Will this have political consequences for the government agent or agency that takes the decision? So that's the tension, private and public. From a mediator's perspective, what can be done about this tension? Let me give you 2 ideas. The first is, I think the tension can be managed by a selection of mediators who are alive to both the private and public aspects of disputes and the implications on the mediation process. A second consideration would be co-mediation. So 2 mediators could work together, one with experience dealing with private actors and the other with experience dealing with public actors. So that's the first tension that I see, and those are a couple of ideas about how mediators can manage that tension. The second tension is a tension between flexibility and formality. Mediation, of course, is simply a negotiation facilitated by a mediator. Mediation works the way that it does because it is a flexible process. The mediator and parties can tailor the proceedings to the dispute and adapt the process as needed as the mediation progresses. And it really couldn't be any other way. Mediation is voluntary, and if there were too many rules, disputants would simply choose not to mediate. On the other hand, states are rules-based entities. State agents may be more comfortable with precise procedural rules for resolving disputes because rules favor predictability and certainty. States may also favor a more structured process. Structures may add perceived legitimacy to the mediation. So from a mediator's perspective, what can be done to manage this tension? I think the mediator can account for the tension in process design by asking questions and discussing with the parties things like who should participate, what will be the venue of the mediation, What is the time frame of the mediation? What will be the nature of any written submission? Will private sessions be used? Just to list a few questions. I've heard of mediations being conducted on the platform WhatsApp. It might be that that's not the right medium, for example, for investor-state mediation. More broadly, I think this tension may speak to a greater role for institutions like ICSID to play. ICSID's mediation rules strike a balance between formality and flexibility. They provide a framework for the process and try and anticipate and avoid problems, but they're not prescriptive about the style of mediation used by the mediator. Parties, particularly states, may also prefer the direct involvement by ICSID or another institution like the Permanent Court of Arbitration in administering the mediation. So that's the second tension, and a couple of ideas about how that tension might be managed. The third tension I wanted to mention is the tension between transparency and confidentiality. Like flexibility, confidentiality is a cornerstone of mediation. Parties are more likely to negotiate openly when they believe that what they say cannot be used against them later. At the same time, one of the main complaints about investor-state arbitration is its lack of transparency. Put simply, the argument is that payment to a foreign investor from taxpayer funds should be subject to public scrutiny. Important steps have been taken to make investor-state arbitration more transparent, including a treaty on transparency, arbitration rules on transparency, and transparency provisions in treaties. There is concern that the selection of a different dispute process, in this case mediation, should not roll back progress that has been made in transparency. So from a mediator's perspective, what can be done? Here are two thoughts. One is to give early consideration to the appropriate level of confidentiality, to discuss the issue directly with the parties, and to come to an agreement. The second is to develop a media strategy, if needed. So in some cases, it may be useful to publicize that a dispute is in mediation or was mediated at some point in the past. So that's the third tension. A couple of ideas about that. The final tension I wanted to mention is not specific to investor-state mediation. It's the tension between facilitation and evaluation. So mediation is often described in terms of how much the mediators are involved in evaluating the strengths and the weaknesses of the parties' positions. In so-called evaluative mediation, mediators are more likely to make recommendations and express opinions. In so-called facilitative mediation, mediators manage negotiation between parties and help them to make decisions for themselves. In practice, both of these approaches may be used by a single mediator in a single mediation. And of course, there are also different degrees of evaluation. However, at the extremes, the processes can look very different. So this raises a question: how evaluative should the mediator be? And should the mediator give parties legal opinions about the dispute? This issue has particular resonance at this formative moment in time for investor-state mediation. Investor-state mediation has the attention of the international investor-state dispute resolution community, and there remains uncertainty about the nature of the process. So from a mediator's perspective, what can be done? Well, first, I think an upfront discussion between the mediator and the parties about what the parties want is important. This conversation, I think, should take place early, possibly even before the mediator accepts appointment. A second option is co-mediation with a facilitative mediator and an evaluative mediator with experience who will focus on risk analysis. And a third option might be a mediator who involves legal or technical experts in the mediation process. This division of roles, with the mediator facilitating and the expert evaluating, might be the best of both worlds. It preserves the benefits of a facilitated dialogue, and otherwise, if mediators are chosen solely on the basis of their ability to evaluate investment law claims, the process may become indistinguishable from expert evaluation. So in conclusion, I see these as four tensions that mediators must consider and must manage in investor-state proceedings. And I'd be happy to return to any of these points in discussion. Thank you.
Thank you very much, James. Now, Daphne, over to you for some thoughts from a government perspective.
Thank you, Jensen. I've been asked to share my views on mediation, obviously from a government perspective. So although in the past week we have heard a lot about the virtues of mediation, I think that it is still worthwhile as a starting point to go back to what are the advantages of mediation, and that will inform how Singapore views the mediation process and why we are such a strong advocate for mediation. So the advantages of mediation. To us, there are clear advantages to mediation which are not present in any other forms of dispute resolution. We have heard a lot in the last week about mediation producing win-win outcomes. So although it's in danger of sounding almost cliche, but I think it's still worthwhile to go back to emphasizing this. Mediation gives a lot more room for flexibility and creativity in seeking solutions. The focus for mediation can be on parties' interests rather than trenchant positions. Parties need not be bound by, or rather mediators and even parties need not be bound by a more fixed set of beliefs based on how parties couch the case. So in other words, it can produce less binary outcomes. Well, one can ask, can't negotiation achieve that? Yes, negotiation can achieve flexible outcomes as well. But where mediation comes in, where it has an edge is mediation gives parties access to the help of a neutral party who is not partisan. And I've been hearing a lot about partisan because we have got a presidential election. And but back to mediation, we can't have the help of a neutral party who's not partisan and thus not wedded to a particular position to help parties to identify what is their interest and then look for creative solutions. And then next, mediation better preserves relationships. We like to say states cannot unfriend each other most of the time, if not all of the time. And even for investor-state relationship, it is also often in the interest of businesses to preserve relationships. And finally, mediation is a consensual process and the outcomes are also consensual. So it gives a degree of control to the states on the outcome. So in fact, I see mediation as quite an Asian way to handle disputes, especially if mediation can produce face-saving ways for both sides to resolve the matters. Well, I accept, I've heard, but I accept that mediation may not be the panacea for all types of disputes, but it is important to give parties a greater range of options so we can fit the right mode of resolving the dispute to the individual disputes rather than force fit all disputes into either litigation or arbitration. So right now, the arbitration system is very developed. There is a plethora of arbitration institutes catered for all types of disputes for businesses, state-to-state disputes, and investor-state disputes. However, in recent years, the spotlight has been shone on the investor-state dispute arbitration system, in particular on the legitimacy of the system. Questions have been raised over whether the system, which is essentially modeled on the commercial arbitration system, is actually fit for purpose. Even while these issues are being debated at various fora, for example, at the UNCITRAL Working Group 3 platform, there is value in looking for more ways and encouraging more ways to resolve disputes. In this regard, Jensen has sketched the landscape. We now have the Singapore Mediation Convention, UNCITRAL model rules, ICSID mediation rules and regulations. So all these contributions are very much welcome. For me, it is always salutary to afford greater options, giving parties more choices. The more scope we give to parties to settle their differences peacefully, whether through mediation or arbitration, negotiation or adjudication, we strengthen the rule of law and peace. At the end of the day, mediation is a consensual process leading to consensual outcomes. I actually struggle to think of what downsides there may be to making it readily available to parties for them to choose to utilize this in appropriate cases. Hence, Singapore has no hesitation in providing for mediation in treaties we are parties to. Example, in many of our FTAs, including the CPTPP, the treaties invite parties to try to settle investor-state disputes through mediation. The mediation provisions in the EU-Singapore Investment Protection Agreement goes even further. The agreement does not only give parties the option to resort to mediation for dispute resolution, it even includes rules of mediation, how to go about selecting mediators, and even the code of conduct for mediators. But this agreement was negotiated before we got all these institutional arbitration mediation rules. I understand that there have been precedents of parties utilizing mediation to resolve investor-state disputes in recent years. This should be encouraged. Now, circling back, I've also been asked to comment on what I think are disputes that are suitable for mediation, or conversely, what are disputes that are not so suitable for mediation. I think much will depend on the nature of the dispute and the factual matrix. But off the top of my head, cases which are not likely to be appropriate for mediation will be cases in which there is a public interest element to have transparent process, open process. So these may be cases whereby corruption or other forms of criminal activity is alleged against the investor. So such cases, there is a clear public interest to have the matter dealt with openly and transparently. On the other hand, what are cases where I see great scope for mediation? I see that especially in dealing with the future challenges confronting the world. For example, matters concerning climate change, pandemic control, technological advancement, and use of new technology. The science and the technology underlying these matters may grow so complex that when disputes arise, the facts and how the law is going to apply to the facts, I think they're unlikely to be straightforward, which means that the litigation risk will heighten. At the same time, it is very likely that the solution to all these wicked problems will need all parties to collaborate with each other, not just governments with governments, but governments with businesses, including pharmaceutical companies, huge technological companies. So take cyber matters and the challenges posed by cyber crime. If there are going to be disputes between a government and technological companies, it may be in our interest, because we need to preserve the relationship to work together, to look for ways to resolve disputes amicably and creatively, so that we can reach outcomes that are acceptable to both, and which will then be more sustainable and that will stand the test of time. So for such matters, I see a lot of scope for mediation. So let me stop there. Thank you.
Thank you very much, Daphne. Thank you very much, everyone, for your presentations and insights. We're already generating quite a few questions in our from our audience, but let me start with something that we talked about in advance, which is perhaps going back to some of the things that each of you have said. There has been this flurry of activity with respect to reform, particularly at UNCITRAL and at ICSID, with respect to creating rules and guidelines. Ultimately, how important are these rules and guidelines for getting the parties to the mediation in the first place? That seems to be, to me, one of the major sticking points, which is not necessarily not having the best possible rules for mediation, but getting parties to see the win-win opportunities that Daphne was talking about. So if it's not the rules, what can we do to help parties see what's in their interest? Bart, well, Daphne, maybe I start with you, if I can.
Okay, let me weigh in on this. Well, we have heard a lot about mediation being a consensual process, it being flexible. But when parties, or when both businesses as well as the government, when we are confronted with a dispute, then you start to look at the range of dispute resolution mechanisms that are out there. And whichever option is selected, it's not just a matter of the lawyers recommending it. It needs political buy-in, because when we go for international disputes, at the end of the day, the government, the political stakeholders must agree to it. It is not possible, I mean, while we say that it is possible for parties to tailor-make or to come up with their own rules and guidelines on how to go about conducting the mediation, that is certainly a possibility. But if there are already rules, especially rules that are framed, that are couched and by credible institutions, and that have been the subject of acceptance by a range of state parties, then it makes it so much easier to moot the idea of mediation to the politicians. Imagine a civil servant writing a paper to ministries and ministers to say, let's go for mediation, say, but we are going to, even negotiate how to go about doing mediation. I would imagine the ministers will say, oh, we are going to be wasting a lot of time, even negotiating how to go about negotiating rather than going straight to the negotiation. So if we can have a reference to a set of rules that are widely accepted and that are put together by credible institutions like UNCITRAL or ICSID, it makes the barriers to access to the mediation process that much lower. So for us, you will need assurance that if you're to go for mediation, whatever is said there, for example, will be protected. That if the government thinks about, okay, if I were to make certain concessions, and concessions are prepared to be considered as part of a total package. But if at the end of the day, there is no settlement for a total package, whatever individual points that have been considered cannot be held against the government. So if there are clear rules that makes the mediation process, including what can be used, what cannot be used if mediation fails, then that would give confidence. And thereby, these rules are not a waste of time, notwithstanding parties can choose to negotiate. They are there, and they would certainly encourage states and governments to consider that as a truly viable option.
Thank you, Daphne. James, would you like to add anything on that?
Sure. It's really just to build on what Daphne has already said. I think she talked about confidence. So I think that the rules can lend legitimacy to the mediation process. And I think when a credible institution like ICSID spends 6 years working on its rules, generates 6 working papers, involves this member states directly in the process, the rulemaking process itself lends credibility to the product in the rules, and simply associating a mediation with an institution like ICSID. A lot of the member states that will be subject to claims are ICSID member states. Some of those states have active barring programs with the World Bank. ICSID is part of the World Bank, of course. So I think it lends legitimacy to the process. As I mentioned, previously, states really are rule-driven entities. I really like that expression. I think I stole it from Bart. I think I heard Bart say that in another webinar. But I think states might be particularly attracted to the idea that there's a set of rules. I think state agents might be comfortable knowing they're going into a process with the certainty of the rules. So that's the first point about legitimacy. A second point is that the rules can serve an educational sort of purpose. So for parties who aren't familiar with the mediation process, they can at least begin to get some idea for the process by looking at the rules. They know better what to expect. And of course, the promulgation of rules like these gives rise to webinars like this, which has a ripple effect in terms of education. And the final point, I think, is about best practices. So ICSID spent a lot of time thinking about the rules, got a lot of member state input about the rules. And I think the product of the rules, they deal with a lot of issues in a very considered and measured way. Things like the authority to settle, raising issues about authority to settle early between the mediator and the parties, understanding the process that will need to be put in place early if a settlement is reached to assure that the settlement can be implemented. There's also an ICSID rule that deals with the issues that should be talked about in an early meeting between the mediator and the parties. So I think that rules like these can also drive best practices.
Thanks, James. And Bart, the same for you, but I guess also just with the add-on, which as I was listening to Daphne and James have been thinking about, and something that you were talking about, which is, given the advantages that can appear or can be developed through mediation, what kind of mechanisms within the state are necessary to help the apparatus of government take advantage of that? You mentioned, how resolving things when it's a ministerial dispute versus a whole of government or state dispute can be critical in terms of casting the dispute and the likelihood of its resolution. How can states, do these rules help states tackle that difficulty of taking action at the right time? Or do states need to make changes internally as well to facilitate their ability to take advantage of mediation?
I think that's an excellent question, and it highlights a really important issue. I fully agree with everything that Daphne and James have said. The rules are important, and they give legitimacy to a process that is not necessarily well known or well understood. I mean, mediation has become a common part of the litigation toolbox in common law countries throughout the world, but in civil law countries, it's still a topic that is not well understood, and there's no real tradition of mediation in resolving disputes in general and public disputes in particular. So there's a long way to go. The rules certainly help, but they're not necessarily enough. As James said, and maybe I said, I don't know, states are indeed rules-based entities. And while there may be precedent or authority for government officials to act in international disputes, including international arbitrations, a lot of states will have no internal framework authorizing government officials to act in international mediations. And it would be helpful, in my view, in many different countries around the world for there to be more of a framework authorizing officials to engage in international mediations in the investor state context or perhaps elsewhere as well, and in resolving disputes, giving them the authority if they think it's appropriate, for example, to reach into the public treasury to facilitate a settlement that's in the interest of the country, and recognizing that resolving disputes amicably can indeed be in the interests of the country, and perhaps even having an internal process for review and validation of settlement agreements reached through mediation by the officials.
Daphne, maybe I could put the same question to you and see what Singapore's practice might be in this respect.
Well, Singapore is a common law country, which Bart referred to. So the concept of mediation is definitely not alien in our legal system or legal culture. In fact, when it comes to our domestic litigation, our domestic court, there are tons of rules to not only encourage parties to go for mediation, there are even laws and rules whereby the courts are equipped with the authority to mandate parties to go for mediation. So I think in Singapore, because the mediation as a process to deal with dispute is already very much entrenched in the domestic legal system. So agreeing to resort to mediation for international disputes, I think the jump is not too high a bar. So so that's the unique position Singapore is in. And when there are disputes, international disputes, be it with another state or with investor, in most of our treaties, a necessary first step is for the parties to go for consultation or to go for negotiation. So if that is already a first step to resolving the dispute, and certainly states have and state officials have always been in the business of trying to first negotiate a settlement, we see mediation as it is a rules-based, in the words of James, is a rules-based type of negotiation or facilitated. So it's a grand negotiation, but with the help of a neutral party. So if we can sort of like look at mediation in that light, then hopefully even for the civil law countries, the bar towards mediation can be lowered, and that there should be no hesitation in authorizing state officials to try this method of resolving disputes. And what must be emphasized about mediation is, at the end of the day, the outcome is consensual. So if there's going to be difficulty, whether selling it politically to domestic constituents or unlocking the treasury to getting a settlement, just don't settle. So, but on the other hand, if this process is available in the arsenal, in the toolkit, to try as one of the options to try to get disputes resolved, I mean, as far as can see, what is the downside to this? So I don't know whether Singapore is in a fortunate position. I am alive to some states having reservations about mediation, especially even for the countries that have ratified the mediation convention when reservations are placed on that. So that's an indication of states having some reservation about the mediation process. But Singapore, we are huge advocates of that, and we definitely see advantages of that. Not for all disputes, but it should be made available so that in appropriate disputes that can still be resorted to.
Thank you, Daphne. James, maybe come back to you on that question of how states can put themselves in a position to take advantage of mediation before the dispute arises, so that they're able to take that decision at an early stage while the business commercial relationship maybe still has a heartbeat, as opposed to when you're in arbitration and it's probably DOA.
Right. Great. I think a couple of ideas about that. One is to consider putting mediation provisions in treaties, thinking about what form the provision might take. Simply mentioning mediation might at least drive a conversation about the possibilities of mediation. But of course, the treaty could go further. There are some treaties that require mediation as a precondition to arbitration. So I think states can think about the advantages and disadvantages of those kind of provisions. And then I really like Bart's notion of the investor ministry dispute. I think as early as possible, if mediation can be engaged as a process, I mean, that bodes well for the process, the success of the process. And I think in order to capture the disputes at an early point, the state should think about how the disputes will be identified and how they will be elevated to decision makers. I think Bart mentioned 7 agencies, an interagency group within the United States. So I think to the extent that states can anticipate claims and that they can think about how responsibility for those claims will be shared among the different stakeholders and ministries, I think that's useful. Assuring that the laws support the process, the domestic laws support the mediation process is something else that could, I think, bode well for mediation. Those are a couple of.
Yeah, no, thanks. I mean, I find it all very, very interesting, and I see a comment in the Q&A, which it's reflective of something that I can't help but think about as we talk about this, which is that for well-resourced states like Singapore or like the United States that are in a position to create internal governance frameworks for taking decisions, even if it is rather cumbersome to involve 7 different agencies. This may be leaps and bounds beyond what many smaller developing states with less robust governance structures they may face different challenges. I think it's perhaps fair to say, and getting into that domestic component does seem to be terribly important in order for states to be able to act, to take advantage of the opportunities that are there. I don't know if that's a question or not. I'm happy for rebuttals too, but it does rather strike me as something similar to what one sees in the investment protection regime, where the idea is that by taking on obligations to protect investors, well, states will naturally see the carrot and see the stick and do their best to reform their governance structures. But life is rather more difficult than that. So I wonder, and I'll stop talking, but whether this is an opportunity where going forward in the UNCITRAL reform process and thinking about the possibility of establishing an advisory center on investment law, this is the kind of issue that capacity building issue that might come within the scope of such an institution.
Maybe before we leave,
Yeah.
Something just occurred to me in terms of treaty practice. Something that I think we haven't mentioned is the cooling off period. So a lot of treaties will provide that a particular amount of time must pass between the notification of a dispute and the initiation of the arbitration proceedings. It's often mentioned that that is a good time for mediation. I think it really depends on a lot of different factors, but a couple are how much time there is during that period, how prepared the state is for the claims. Is it even aware of the claims? And then I think something else relevant is the technical requirements in the notification. So these vary a lot from treaty to treaty. Some treaties aren't very specific about what is required for notification, and others are very specific, requiring things like an identification of treaty provisions and supporting documents. And so I think where the notification requirement, it demands a lot of the investor, then the state will, on the other side, get a lot of information about the dispute. And then I think it helps them to go internally and process the dispute and maybe respond more efficiently. If there's not enough information in the notice, then it may be that the state just isn't prepared to mediate during the cooling off period.
And Janssen, just to provide a practitioner's perspective, and much as it pains me to disagree with you about anything, I'm not sure actually that the smaller states are necessarily less able to engage in mediations competently. My own experience as a practitioner has been that the authoritarian governments are typically much better placed to make decisions and to act quickly in resolving a dispute than the democratic governments that have this cumbersome machinery with lots of different people involved, some of which will of course look at their watch and say, oh, it's 5 o'clock, time for me to go, bye, let's pick up our discussions at 9:30 tomorrow morning. That doesn't necessarily happen in authoritarian states.
Can I weigh on that? When you posed that question about the resource constraints of certain states, which you described as not as well endowed as Singapore in terms of resources for such matters. What the thought that went through my mind is ironic, isn't it? I mean, if there's going to be resource constraints in getting on board the mediation train, I mean, if the matter is not resolved, then certainly for investor-state disputes, what is going to come on next is mandatory arbitration. So if the state is not going to invest resources in trying to get it resolved, especially at an early stage, as much as possible, then they are going to be confronted with, I think, a bigger legal bill when it comes to investor-state arbitration. But apart from that observation, I do see a place in educating states on the availability or what this mediation process is all about. And I think Singapore is trying to contribute towards that effort by even organizing the Singapore Convention Week. I also see merit in setting up advisory center. And in fact, Janssen, maybe the Center for International Law can play a part in that. Or how about UNCITRAL? The UNCITRAL setting up a small office to give information and to look into capacity building for states who are not close to the idea, but need some capacity some capacity building in order to understand what are the technicalities involved.
Thank you, Daphne. We're happy to help anywhere and anyhow. And thank you, Bart, as well. We can discuss the nuances of those points at another time. I do want to follow up on some questions that are coming in the chat, and they, I think, go to one of the tensions, James, that you were identifying at the outset, the tension between transparency and between confidentiality, and where the right balance should be struck in transparency of the process, transparency of the outcome, vis-a-vis, of course, the public, which, as we've already said, may be the ones who are ultimately paying the bill through the public treasury. But also just in terms of other stakeholders who have an interest in the outcome of this kind of dispute. And one of the notable things is that 10 years ago, much reform was being focused on ensuring that non-parties to investor-state arbitrations could be assured of potentially participating in order for stakeholder views to be heard. What's the role for these third-party stakeholders in mediation? Well, I guess I was putting that to you, James, but
Yeah, no, I'm happy to take it.
There was a question mark without an obvious question. But let me put it to you first, if that's all right, and then
yeah, happy to.
You had your hand going.
Absolutely. So, one of the advantages of mediation is its flexibility, and as long as parties agree, they can do things that wouldn't be possible in arbitration or as easy in arbitration, including bringing third parties into the process, non-disputing parties into the process. So, at least in theory, the mediation process is more accommodating of third parties than arbitration is. As you mentioned, Jan, institutions and rules provide the possibility of third-party participation, but it's a much more circumscribed process that one must go through to involve non-disputing parties, third parties. So I think the starting point is to recognize that mediation is a flexible process that is very accommodating. I think another advantage of mediation is that the universe of issues that can be discussed is much bigger. In an investor-state arbitration, it's really the arbitrators applying the law to the facts and drawing conclusions about the claims that were made. In mediation, really anything related to this dispute can be discussed. So I think that also offers more scope in that process than for discussing third-party interests than might be possible in arbitration. I think maybe the difficulty is just that mediation is a voluntary process, and so the participation of third parties would require agreement of the parties in the mediation.
Sorry, Bart. Yeah, go ahead.
Sure. So I think, I guess, two observations. So the first is that there are a number of investor-state disputes where the dispute cannot be resolved amicably without the participation of members of civil society. And I'm thinking, for example, of projects where a given concession is located in an area where there's an indigenous population or a population with specific characteristics, and the dispute ultimately can't be satisfactorily resolved unless that group agrees with the outcome as well as the government. So there are a number of cases where it's critical to have members of civil society involved. On the other hand, mediation is a negotiation, and it's not a situation like arbitration or court litigation where the government is presenting its official position on things. Instead, it's a negotiation where there's negotiation strategies that are And sometimes in a negotiation, a party asks for things that they don't really want, but they ask for them because they know the other party doesn't want that. And they're prepared to take those off the table at the right time in exchange for something else. And one of the great benefits of mediation is it allows the parties to know or to have a good idea as to what is really important to the other side and what is not. And that's one of the ways in which a mediator can help the parties to arrive at an amicable resolution. But my point here is that transparency in mediation can give rise to a lot of misapprehensions, because if the public is following the mediation and they think that it's really important for their government to have X from the investor, and then the government, in the settlement says, okay, we're giving that up, then that can give rise to misunderstandings as to the competence of the government, what was actually obtained in the negotiation. And so that gives rise to issues both with respect to the transparency of the proceedings, and also the involvement of members of civil society, because certainly when you're developing deploying a negotiation strategy, you don't want the other side to know what that strategy is through leaks, through people who are not necessarily part of the negotiating party. I'll stop there.
I don't have anything to add. I agree that with everything that James and Bart have stated. So if there's a need to involve the NGOs in order to achieve a settlement, since mediation is a flexible process, that's something that can be considered, and I think more easily considered than in the case of arbitration. For arbitration, I mean, if the NGOs are going to come in, I mean, for the government, you start to think about, oh, there's another set of pleadings that you have to deal with. It's going to add to costs, etc. Whereas for NGOs, if their views can help in the settlement process or is necessary to achieve a settlement, can easily be taken on board.
Let me take a question from the audience, which a couple of them actually, which I think get into the formality versus flexibility tension, and also how to best deploy the flexibility that's available. And one of them concerns in mediations involving complex disputes. How important is it to have the actual decision maker in the room while the mediation is occurring? The person who ultimately can make the decision as to whether or not a mediated settlement can be found. Is there, just in terms of experiences, getting that person in the room, keeping them there for the length of the mediation may be a bit challenging, but what are your general thoughts on that issue? James, perhaps start with you.
Sure, happy to. A couple of points. I guess one point is that obviously the ideal is that the ultimate decision maker is in the room. But I think one thing that the ICSID rules do that's very interesting is they require the mediator and parties to talk about what will happen if the decision maker can't be in the room. Basically to describe before the mediation session starts the process that will be necessary in order to finalize any settlement agreement that results from the mediation. So I think if it's not possible to have the final decision maker there, at least it's important to be clear about the process necessary to get the conclusion of the settlement agreement at the start of the mediation. And then a second small point is just, we're here online today. I think that the possibility of having mediation online does facilitate including people in mediation who might not otherwise have the time to travel to a physical mediation. It's not to say those people would need to be available for the entire mediation, but it may be that people higher up in organizations, for example, could better justify attending at least part of a mediation that takes place online than in person. I'll stop there.
For investor-state type of disputes, I mean, at least the practice in Singapore, it's likely that it will be the state is going to be represented by the lawyers, specifically lawyers from my department. I take charge of the international law department in India's Attorney General's chambers. So it's likely to be the lawyers, but the lawyers are typically not the policy maker and therefore not the decision maker. But so I think it's helpful for the decision maker to be in the room, but certainly in Singapore's case, it is that is unlikely to be the situation. So what I see as helpful is if the decision maker is within a call away. And I mean, I can well see that if Singapore were to be involved in an international dispute for which we're going to go for mediation, a lawyer who's going to be well trusted by the policymakers will be appointed. And I can also foresee that the decision maker will certainly also make himself or herself available while the mediation is ongoing, so that decisions on whether to settle can be taken quickly. Because I think sometimes you do need to catch the moment to when you hit what I call a sweet spot to achieve a settlement. And if what is going to hold up the process is we can't get the decision maker, I think that would be a pity.
So from a practitioner's perspective, I've never seen it where a decision maker was in the room during a mediation or a conciliation of an investor-state dispute. Now, these have all been with the ones, my experience thinking back over it has all been with countries that were from a civil law tradition rather than a common law tradition. But in each one of those cases, it was a situation where a settlement was negotiated or arrived at through conciliation or mediation. And it was approved within the government at some later date. And that later date was not the next day. I can tell you that. It took some time. So these things, I think, typically do take time. And a lot of times it's not possible for the decision maker to be in the room, because it may be that what's being contemplated would require a legislative amendment or adoption through some kind of administrative process. And therefore you simply can't have a decision maker in the room. It's just not feasible.
So, but will the persons representing the parties for mediation not have already gone into the mediation with a range of options that are possible? And once a particular solution becomes possible, I mean, won't the parties just want to settle then? So I'm just a little surprised that your experience is that the settlement process sounds like it drags out over time.
Well, if the state makes an offer and the investor says yes, then that would be one thing. But if there's a counter offer, as there often is, then it takes time. That's been my experience. And in one of the situations, it was more of an evaluative mediation, not where the mediators were providing a view on the parties' positions, but where they provided a view on a possible settlement that neither of the parties had seen.
Right.
Which ultimately was acceptable to them.
That actually is a segue to another question that's being raised in the chat by a number of different people, and that really comes down to, again, questions about best ways to use mediation and the flexibility built into mediation, and essentially concerning at what point can a mediation take place? Can the parties choose to mediate in the midst of their arbitration? And certainly, I think as a matter of the convention and the rules, we know the answer to that is yes. But have you seen it? And what might be the advantages or disadvantages from your perspective? But also, I think perhaps more interesting, using mediation on a specific subset of issues or questions that are at play in a dispute, without necessarily putting the entire dispute to the mediators, and whether that might be an advantageous route in certain circumstances. So I'm not going to call on anyone. I'm just going to leave mics open, and please do jump in.
I'll have a go at it. At what point will a mediation be the most effective? My own view is as early as possible. In fact, if a dispute threatens to break out between the state and the investor, I think before both parties crystallize or dig in, crystallize the dispute or dig in their position, it may be a good time to consider whether sending the matter for mediation to actually prevent the dispute from fully crystallizing may be helpful. So instead of, so in other words, instead of seeing mediation just as a tool to resolve or to decide on disputes, but it's actually using as a tool to diffuse the dispute. And if a claim is already filed, I think before the pleadings are filed, mediation should be considered. My concern is once pleadings are filed, the parties have already moved on so far in the case and incurred so much cost that going for mediation may not serve as much purpose. And for a state, if after we look at the pleadings, the submissions, and there will be concern that if mediation is proposed, it may be seen as a sign of weakness on the part of the state, or the state not believing fully in its case. So my own sense is, notwithstanding that technically mediation can be resorted to at any point in time, I see it as most effective if it is considered as early as possible. And in fact, hopefully before the dispute even crystallizes.
Maybe just to build on that a little, I think also to your point, Jan, about simplifying disputes. If one of the great advantages of mediation is that it enables disputes to be resolved more cost and time efficiently, then maybe resolving one particular issue in dispute and leaving the rest to go forward in arbitration might have the impact of simplifying the arbitration and making it faster and cheaper for the parties. So I think it at least in theory, it could play that important role. In terms of mediation during arbitration, there was a study done a couple of years ago, Herbert Smith Freehills and an arbitration and mediation institution in London, and they looked at mediation in arbitration, that is mediation once arbitration is underway. And the success rates of mediation in arbitration, and this wasn't specific to investor-state disputes, it was generally commercial mediation, but success rates were surprisingly high. It may be that once the parties are in the arbitration process and they began to see more clearly the strengths and weaknesses of their disputes, perhaps at a point before a lot of money is spent on a hearing, for example, there might be a fresh opportunity to reconsider mediation.
So I agree with everything that's been said. I guess on the question of breaking up mediation and only dealing with a specific part of a dispute, my own experience has been that if parties want to have peace, then what they want is a complete and lasting peace, and not necessarily to have war on some issues, but peace on others. So it's a possible solution for simplifying an arbitration, but it may be not the most desirable solution because it's usually better to have a complete resolution of the dispute. Mediation during arbitration is not only possible, but I think it can be desirable in a number of cases. One often hears from clients concern about, oh, it will be a sign of weakness if we engage in settlement negotiations or mediations. My own reaction to that is who cares? Who cares? Because if you're going to go through and get an arbitration award, no one's going to tell the tribunal that you've engaged in negotiations. And if you do, the tribunal is simply going to say, wonderful, we're so happy that you did that. And if you take it through to an award, then it doesn't make a difference to anyone that you've engaged in mediation, unless it's successful, of course. So I try to talk clients down from that view, but it is one that's often heard. And then the final thing I'd say is that for mediation during arbitration, mediation is a really intensive process, and it requires complete attention of everyone involved over a short period of time. And so it can be logistically complicated to have the entire client team and the entire arbitration team focused during what can be a critical period of the arbitration on mediation. But that's a logistical issue that can be resolved by either having a suspension of the proceedings or handling it in some other way. But it is something that has to be addressed.
And I suppose that could be dealt with in procedural order number 1 in arbitration, at least in theory. It could be that the arbitrators provide the possibility of a discussion about mediation to the parties at some particular moment in the arbitration proceedings, with the understanding that the proceedings will be stayed during that period. It could be that the arbitrators at least put that possibility to the parties when finalizing procedural order 1, and that way there's at least the opportunity for them to talk about the possibilities of mediation at some point once the arbitration is up and going.
And in fact, the new version of the template for procedural order number 1 in ICSID proceedings does contain a reminder to the parties of the possibility to resort to mediation at any time, but it doesn't really go much beyond that. So it's, I think, a helpful step in the right direction. Perhaps it could go further.
We're getting towards the end of our allotted time, but let me move us for a moment to talk about the arbitrators themselves. These beasts that we're told are going to become more prevalent in investor-state disputes, but as yet are still pretty rare. Over the summer, of course, the UNCITRAL Commission not only dealt with mediation, but it also dealt with codes of conduct for arbitrators and for judges. And much has been debated about arbitrators and ethical rules for them, particularly on the double and triple hatting question. Going forward, are we going to need to have this same debate with respect to mediators and mediators who act as counsel in some cases, or arbitrators or in others? Do you see the development of a mediator class specific to that role, or is that something that anyone with experience in investor-state disputes can take on? And I guess, Daphne, there is a question specifically, Singapore-specific question, which is moving forward. will there be plans to regulate the practice of mediators in Singapore, particularly if they partake in cross-border disputes mediation?
So in Singapore, I'm aware that there's an institute that accredits mediators, but that is on a voluntary basis and not mandatory. So it's not like one must be accredited or one must have a license to practice as a mediator. So and I'm not aware of any plans to go in that direction. So, but I'm not a policy maker, so I've not heard of any plans to go in that direction.
Thank you. The usual caveats apply. Yes. James, Bart, on the question of
Sure.
codes of conduct and mediators.
Sure. Yeah, you mentioned a mediator class. I guess one observation I have is that I think the processes are quite different. I think it's certainly not a given that a good arbitrator will be a good mediator. I think the skill sets they can be comparable, but I think there are some significant differences. And so I see real value in bringing into the process the facilitated negotiation piece. And so I have some trepidation thinking about arbitrators providing mediation services that consist only in legal evaluation. I mean, already this can happen outside of the world of mediation, and it might really cloud the waters between mediation and other types of disputes. So those are some observations about the mediator class that you mentioned. In terms of codes of conduct, I guess the one thing that I would mention is that mediation is an entirely voluntary process. So if any party is unhappy at any time, they can simply walk away. They can terminate the mediation. So maybe there's a greater concern for the behavior of arbitrators in some senses because it's not a voluntary process, and also because they'll be making a decision at the end. And the mediators, they might be helping parties to assess risk and to generate solutions, but the mediator won't be able to impose a solution. That's one difference that may be relevant to any sort of instrument that would deal with the behavior of mediators.
So I would fully agree with what's been said already. The role of mediators is different from the role of arbitrators. And as James said, the idea is for the mediator to help the parties come to a settlement. It may be that from the investor's perspective, the best mediator for a given case might be, for example, a co-mediation where you have an experienced mediation professional like James, coupled with an important regional figure like the former president of a country. I'm not making reference to that because of the election in Singapore, but someone who's got a great deal of respect in that country in order to allow the parties to arrive at a settlement that will be seen within the country as being one that's a fair settlement. And it might be that that applying the code of conduct that's applicable to arbitrators, that former president would never be able to act as an arbitrator, but as a mediator, she might be the best person for the job.
Well, thank you all. I am just, bear with me, checking on one last question, which is come in. We have about 5 minutes left or so, and I guess before we end up, it's an opportunity to offer each of you a chance to say things that you wish you'd said already, or say things again that were particularly important, or retract things that you wish you hadn't said. Or do nothing and say thank you very much. Daphne, would you like to?
Only one sentence.
Yes.
Give mediation a chance. It is an option. It's always good to increase the choices for parties. So I'll end there.
Thank you very much, Daphne. James, let me turn to you.
I couldn't say it better than Daphne. I think give mediation a chance. And if you're unfamiliar with mediation, it's a great time to be alive because there are lots of places you can look to read about mediation, better understand the process. So please keep that in mind.
Thank you,
And
James.
I can, of course, only agree with my co-panelists. I'd simply highlight that because of the caucusing process, where a mediator meets separately with each party, the mediator can see possible solutions that neither party would ever be able to see because they don't have that access into the thinking of the other side. And that can allow mediation to find acceptable resolutions of disputes that the parties could never come to by themselves. So indeed, give it a try.
Well, thank you all very much. It's been a great discussion, and very appreciative of all of you taking the time, especially Daphne on a public holiday here in Singapore.
I've already cast my vote.
Well done, well done. Civic duty discharged. So thanks all to our audience for joining us today, and thanks to the Ministry of Law for inviting the Center for International Law to arrange this side event for Singapore Convention Week. With that, I bid you all a good day. Bye-bye.
Thank you.